Yes.
But basing on the last query made by this honorable court, basing on the last query made by this honorable court with respect to the genesis of chapter uh, that deals with the disciplinary proceedings of the police manual, I have received this specific instructions. Your Lordship may, I'll share it. Oh,
Yes.
Lord, the next question, my lord. We also, I also tried to pull out from
I
the.
think the superintendent of police should come and argue the point of law.
May I plead with the Lordship, my lord?
Yes.
My lord,
The way he has written an instruction, I believe so that he will be able to justify what he really wanted to say.
With all sincere effort, Miller, we tried to find out because this is a manual of 1940. So we tried to find out the very genesis and the basis, how it has been, whether it has been notified by the government or whether it was placed before the assembly in terms of Section 7 of the Odisha Police Act, and whether it has been placed before the cabinet or cabinet approval. Tried to find out from the director of prints. Now the director of prints, as I have received from the state police headquarters, this is the instruction. If your lordship may kindly see. The second page, my lord. No copies. So the gadget
You remember?
notifications are available. The only copy of the Odisha Police Manual which was available in the
Oh,
state.
that is what it says. That
Yes,
nothing is available, no notification, nothing on that.
that is not available. But the copy of the Odisha Police Manual, which is available with the state police headquarters, in fact, it was in the mutilated state, so I could not bring the original one. I have taken some photocopies. Your Lordship,
Extract. This is what is
The instruction given to you, these are privileged communication between you
no,
and
I
your
am
client.
only sharing.
Unless
the-
you those things on record, why should we rely upon all this?
I'm not trying to rely on it. Only because there was a specific query put by the honorable court, so that is why. But this police manual, if your Lordship will look at the forward and the preface, that is only which is available. This manual is a lineal descendant of the Bengal Police Code, and it's by
Our
the
query was
yes.
the rules which are envisaged in the Orissa Police Manual rules,
Yes.
or whatever is called, where there is no asterisk, has it a force of law? Can we construe it as a force of law?
It cannot be. It cannot.
So
be
what
done.
are we deciding now?
Now, if it
So
doesn't,
why should we interpret the rule which has no statutory backing or force, as you said, as you are admitting?
but I am only, my lord,
So
I am
what
only
is
on the.
that aspect.
Yes, my lord, one judgment of this honorable court in 1972.
This question might not have arisen there.
But what the honorable court has observed, that is important, my lord.
See, observation of court under a particular fact situation, and the question may not have fallen there.
While examining rule 853, what the honorable court has observed.
So we can definitely look into this aspect as well as the ancillary and another point of view.
My lord, this is reported in 1972 SCC Online Odisha 191. Your Lordship may kindly see para 23.
What is this 1962 rules?
1962 rules is the Odisha Civil Service Classification Control Conduct Rule. In respect,
That is
there.
quite justified. That
Yes.
has a statutory force.
Yes.
But so far as this rules are concerned, we were just inquiring from you that what was the genesis, because these were framed during the British era.
Yes.
Now, what?
Now,
Government of India Act was there.
yes. But whether this particular code, as like the Odisha Service Code, were framed in terms of the provisions of the Government of India Act, and whether it enjoys the status
The
of a statute in terms of 313 of the
continuity under
Constitution.
the Constitution of India can be definitely seen.
Yes.
No difficulty. It
Yes.
says unless superseded by a subsequent legislation, those legislation will continue.
Yes.
But under the Governments of India Act, one has to say that what
Whether these rules have been framed or not. So that is not available, my lord.
completely blurred.
But I have tried all my best efforts, and because 1940 these documents are not available, and only place where I have not searched is my lord's library, where there is also compendium of gadgets and everything, but that is the only way that may show, because that is not available.
Anyhow, there are two. We will consider that,
And-
in our
and-
own way. We'll consider.
And
it.
I'll be failing in my duty in one of the cases also. The Honorable Supreme Court in 2003 have made certain observations with respect to this particular police manual. Because if your lordship may kindly see this, sorry. Yeah. Para 14 is important, my lord. Your lordship may find, because this judgment I could find yesterday only. Para 14. We've gone through the police manual.
Goes against you.
Yes, I know that, because I'll be failing
No,
in my
no,
duty
no.
if I don't bring it to the notice of my.
Well, thank you. It goes against you. It says it's not a statutory.
Yes, this
Now,
judgment says.
now, why I say that why this question arose was that there may be a certain documents which will be used as a guide for the
Guideline.
purpose of the functioning of a particular organizations or the functioning of a particular department.
Yes.
So those are all having an executive nature. These are all of executive nature. The question is that whether these executive instructions or the guidelines, whether is legally enforceable document, is the question that really arose in our case. If it is a legally enforceable document, then the third party who is not connected with that particular guidelines, whether he has a right to enforce that and say you are bound by it. This is what really appears to us. And this judgment has got a no statutory force.
Yes,
It's only a guideline. That's
it's
all.
a guideline.
That's all.
But my lord, once it is only a guideline, and this guideline having been followed for a long standing period prior to constitution and post the constitution, my lord, what would be the necessary effect of that guideline? The lordship may kindly. My lord, if I may place, my lord, Article 13, the lordship may kindly see constitution. In fact,
Yes, that is what I said.
Article 13 reads
Certain,
with
certain
313.
rules, certain regulations which were
Yes.
there.
Does it assume statutory?
It, although it doesn't have a statutory effect, but it has to
Talks
be.
about it. The
So,
previous law will continue
continue
unless it affects
unless it
upon that fundamental.
That's there.
Article
We are
13.
now
Now
on
the
the
question
question.
is laws, whether it is a law.
That's the question.
We are on the question now. That is marks which have some statutory executive instruction force vis-a-vis non-statutory, non-statutory.
But only this.
We are in between.
Yes. The asterisk marks.
The judgment of this court
Yes.
proceeded on the basis of appealable factor.
Yes.
That is under a different context. There was no statutory or non-statutory factor there.
Yes.
We are now harmonizing whether this non-statutory rule will have any impact over the statutory and read in harmony with that,
But the statutory
because
basis
you
of the
have been
entire,
following it.
that is completely blurred, not available, my lord. All that, my lord, from,
Article 13, when you talk about,
yes,
it has got two facets. One is which is a primary the limit is that all the laws which were there prior to the commencement of the Constitution, unless it is repugnant to or inconsistent with the fundamental rights or any of the constitutional rights, will continue to have in force.
yes,
Now, then the question arose, what meant by laws? In clause subclause 2A, it is defined that what is a law. It also includes the orders. It also includes the many facets which are considered to be the law, but circumscribed by certain more qualifications must have been done through some kind of a backing or a law to operate. Then it talks about the laws in force. What does it mean in clause B, sub B? Laws in force says that which is applicable, framed according to the provisions which were prevalent.
my lord,
And therefore, what is there is, that's why I say, whether it is a legally enforceable document, one can enforce as it or as if it is a law.
if your lordship may kindly see 13B.
Say laws in force, please read that.
Laws in
What it
force.
defines means what?
Laws in force includes laws passed or made by the legislature.
That is what is the important, whether it is done by a legislation.
My lord, the next line, or other competent authority in the territory of India before the commencement of the Constitution and not previously repealed, notwithstanding that any
Now
such
the word
may be-
competence authority, the competence really comes an authority to make the law.
That is sub-delegated legislation talking
Yes.
about. It's not in a sub-delegated legislation.
Either delegated, subordinate, whatever, you have to, the competent authority, when it talks about, the authority must be competent enough to frame those rules.
Who's a power was still there?
Yes. Otherwise, the word competent authority has no meaning. The legislature would have used the word authority.
Where from the competency comes, the source
Yes.
has to be defined. Source is either from the statute or from the constitution.
source, my lord, from the Indian Police Act, Section 7.
But it does not
Read with,
provide for this manual to come.
but this manual, the
It does
very
not. It
genesis
says
of this
rules,
manual is not
it
available.
says rules, regulations,
That I
and
can-
everything can be done.
Although it says that it receives the sanction of the state
But at
government.
the Supreme Court, I would say, in a very, very, I would say, very aptly said in this case of Ajam, Kumar Bhuiyan,
Yes, Ajay Kumar Bhuiyan.
Ajay Kumar Bhuiyan. He says no statutory force. If it has no statutory flavor, can you force anybody to have on its ballot?
The question is, my lord, these provisions have been interpreted as like statute by the tribunal and which was confirmed before the division bench. Then confirmed by the apex court with a rider that the
But this
question of
question-
law is left open.
No, this question was never raised. That's the way things are going on. Now
Bec-
this is
Yes.
right, and you have to answer it.
So the learned tribunal has only decided on particular provisions. It has gone to the genesis.
This is one of the observations.
Illegality once committed, cannot be permitted to perpetuate for all time to come.
That's what you are saying. This is being recognized by other tribunals and high courts and all. So keep on doing it. After having
No, the point which has been raised before this honorable court, presently by the honorable court, with respect to the genesis of the statute, that was never before the tribunal. All that the tribunal has interpreted it like a statute.
Not even in any other judgments,
Yes.
except the Sajay Kumar Bhuya, at least the Supreme Court has come up,
Has only gone through, but
have
even
gone
that-
through but one line.
Yes.
It has no the recognition.
But the judgment rendered by this honorable court in 1972, it says that it is a self-contained code and
True, that is what, but the Supreme Court has said otherwise.
Because of this tribunal observation in para 11, you see, it is also interesting to note that even before the tribunal,
yes,
administrative tribunal, and the bench which decided on 22/10/1990, OA number so and so, so and so, so and so.
Yeah.
Those statutory rules have been filed and are referred to in order itself as Annexure 3 to OA number so and so, and their promulgation on so and so itself. But the fact remains that before this court, on that occasion only, the provisions contained in manual had been produced, necessitating a comment on 12/4/1993. As stated earlier, it is most unfortunate that the state had not till date framed these statutory rules. It is high time that statutory rules should be made instead of relying upon pre-existing administrative instructions. Under these circumstances, no discrimination has been shown within so and so.
it appears to
So this
be
is the observation of the Supreme Court, which you have not taken care of till date.
it was
It
appears to
is
be understood.
very apt. Sorry.
And it is understood as if this manual is a compilation of all rule, regulation, executive instruction, everything.
but
It was
says-
understood that way, but it's going on.
but it says that certain provisions of this manual, which draws its origin from particular provisions,
Correct.
those have the sanction of the government, but those sanction orders are not
No,
available.
that is a different.
Yes.
That is why this judgment in Ajay Bhuya, if you come to paragraph 14, which we are referring at page 16 of the judgment, at the bottom, the last line, if you look at it, just last line, the sentence beginning at the top of just last line, bottom, at the top of some of the chapters, particularly chapter 20 relating to appointments, engagement, a specific note is found printed that rules marked with asterisks have been sanctioned under section 7 of the Police Act. The conspicuous omission or absence of such a specific indication, either at the top of chapter 27 or in respect of any one of so-called rules enumerated thereunder, as to their nature and character, or showing them to have is any statutory origin, it has to be presumed reasonably and necessarily to be not statutory. Then the case of state of Rajasthan versus Ramsaran was considered.
Yes.
This court had an occasion to consider this aspect and hold that only the rules or orders passed by the government under section 2 of the Police Act alone can be said to constitute the conditions of service. The rules envisaged to be made by the Inspector General, subject to the approval of the state government, even under section 12 of the Police Act, are considered to be not such which could deal with or relatable to the service condition of the officers recruited to the police force. Even the decision relied upon by the tribunal for its conclusion in the state of UP versus Baburam Upadhyay and Jagannath Prasad Sarma would go to show that what was considered to be continued by virtue of Article 313 of the Constitution of India as existing law where only those statutory rules or regulations made in exercise of the powers conferred on the government under the Police Act, which stood preserved under Section 243 of the Government of India Act 1935, and therefore held to continue to be in force even after the Constitution, so far as they are consistent with the provision of the Constitution.
Yes.
Law enforced, as is defined in Article 13, subclause B,
Yes.
law enforced for the purpose of Article 313 of the Constitution of India were considered to be the only those which were framed in exercise of various statutory powers vested with the government, including the powers under Section 7 of the Police Act, and not to confer such statutory character to each and every one or the other of a so-called rules. As a matter of fact, in Union of India versus Maji Jangamaya, repelling a similar view was in respect of an administrative instruction of the government conveyed through the Central Board of Revenue. It was observed that an administrative instruction or the order is not a statutory rule, and that Article 313 does not change the legal character of a document. And then it's quoted, the rules that were under consideration in a decision of B.N. Nagarajan were held, though to be under Article 309, but traceable to the powers of the government under Article 162, that is by a governor of the Constitution, therefore binding in absence of a rule under Article 309. The same cannot be said of a police manual of the year 1940. Consequently, the baseless assumption of the tribunal which rendered the decision on the view that the rule noticed by it had a status of an existing law without specifically pointing out under what provision of law they were or could have been made is totally erroneous, and for that also beholds the binding nature of an earlier decision of the tribunal. Kindly consider you are arguing
Yes.
the same thing, as well as this court. And despite the judicial norms, proprietaries and the decorum violated also cannot be justified in law on merits as well.
Everything is answered.
I think whatever you are arguing is answered.
So I have gone through this. Now,
Your
all that-
Article 13, everything is taken care of.
yes, everything has been taken care of. Because yesterday
The
night I could,
classical judgment which has come.
yesterday night I could.
No, thank you for that.
Only I pray, madam. Can I pray, madam?
In the face of this observation, do you need these references to be answered or not? You tell us. On the face of this observation. Answer that.
Then what would be the
No,
necessary
that's a different
consequence?
story. Answer. You have to tell us on the face of this observation, do you need to answer the reference?
If he holds it as, then can you?
You may not be the
You need a little bit more
So
research on that.
I have, in fact, my
No,
lord,
that's a fairness you have shown. And has this judgment, whether this judgment has been considered subsequently or have been relied upon or is distinguished on facts? Have you checked up?
that because
Mr.
this
Kuntia,
judgment I could only pull out
Mr.
yesterday.
Kutia, you had
That is what.
much of experience in both
Whether
sides.
it has been considered subsequently by you.
Mr. Kuntia, both sides is service expert. Both sides he was.
What is your
So have
reaction to
have you
this
never-
observation? This is a very alarming and very enlightening observations made in
Yes,
the-
I
The
know
manual
that.
goes.
Yes,
the manual has
I know
been
that.
thrown completely. If a document is thrown completely, then any action taken on the basis of that document has to go.
It will affect either way. It will
It's a
affect,
double-edged sword. No,
yes, it will affect the state as well as the other side also.
It will not.
Because
no.
State may be more affected.
yes,
Mr. Kali Mishra, Mr. Kali Mishra, you have been conducting police cases. I have been seeing since
40
long.
years around.
And you did not take this plea anywhere.
But he must be taking advantage of that.
Well, I know where to argue, where to stop. For that purpose, I sit down.
but if your lordship will look at the
But the
manual as a
difficulties,
whole,
I tell you, this police manual is being used, utilized, applied indiscriminately throughout the countries. And there was not a single whisper anywhere about the competence of the
Section
police
7, they are
and
all
the adoption of the provisions contained in the police. So this is the first time when this question that arose, and now this judgment, I do not know, it's a standalone judgment or is being followed consistently.
that I'll
I
have
don't know. There are certain judgments which are standalone judgments, only one.
I'll have
After
to-
that judgment, state has framed a rule in respect of recruitment of junior assistants in their head office.
So that
But-
the state is competent.
Yes, they
That the
have framed-
state is competent to do that. There
yes,
is
they
no
have framed that
difficulty.
rule.
If they have a rule-making power deriving from that power, as it says, Article 309, Article 162, no difficulty. When there is nothing, it can be supplemented, not supplanted the main act.
Yes.
Is supplemented by taking recourse to those provisions. No problem.
Only rule, that rule is framed, except that manual.
That they are taking plea of Article 313 and this is
313 has been
That's true,
decided.
I've
It
read
says
the
no,
document, read it up.
because the existing
I've
law
read it, but
must be read
that's
in
what they are
conjunction with
interpreting that. That's what they say.
Article
That
13.
is the
Laws
plea
in force or
Yes.
the laws what it
Yes.
means.
They are taking a pre-constitutional, therefore it is continuing. Therefore, it has a force of law, as your lordship rightly read. Unless legislative competency or competency, and have competence means must have an authority. Authority empowered under a statute or otherwise to pass any or frame any rule. That is the law. All right, sir.
this police manual not only deals with departmental proceeding, but it deals with other issues also, which my lord, now the question is, everything will be unsettled if it is
True. No. If the action has already been taken,
yes,
that will not go
yes,
in that way. That it will not upset the. I'm thinking of this doctrine of factum valet.
because it deals with recruitment, it also deals with promotions, it also deals with
That's why I'm
training.
saying
everything.
I'm deriving that particular doctrine of factum valet.
You can regularize it, not that.
No, that will go. It will not invalidate if the action is written. But prospectively,
Only prayer I can make, my lord, for now only. And since I could pull out this judgment yesterday night, let me ponder upon, my lord, whether this has been set aside or
I tell
must
you,
have been heard.
it has a far-fetched consequences,
Yes,
far-reaching consequences,
yes.
and it will really
I
affect-
know the
affect-
consequences because I'm I'm
is
only
not within the state,
concerned.
but pan-India is a central legislation like that.
But after this observation in this
this
Supreme Court,
police manual is
they
only
should have
sub police
taken care
manual.
of
But
by now.
yes,
This police manual, everywhere it has been quoted,
yes.
is kind of a central legislation. Looks like.
Let me
This
also
point struck because there was in other state there was a land manual which was framed. With the lands, settlement of lands, mutations, and all everything was there. Question arose whether this land manual has any statutory force, because the government was taking shelter under this land. Then it was held by the other High Court, says it's an executive instruction. It has got nothing, no force of law. You can't decide the right of the parties taking aid of a particular manual, which is merely an executive instruction.
State of
Absolutely.
this this case has been referred.
Distinguished, or my brother is more tech savvy than any other person. He has already found out that two judgments that are relied upon or is being referred. This judgment is referred.
May also go through those judgments. Lots may
You do
grant
that
me some time.
Relied upon. Relied upon. State of Punjab versus Satnam Kaur.
Okay. Huh.
2005 supplementary 5 SCR 891.
Can you find out that Nasli Wadia judgment also? Nasli Wadia judgment. That was in relation to the Public Premises Eviction of Unauthorized Occupants Act. There also one, the guideline or the instructions came from the government. And then it was argued whether it has got any statutory force. Any third party can enforce it. The court says, no, you can't enforce it. It's an executive instrument that is not legally enforceable in law. There we go. Nasli Wadia versus, I think, LIC or what?
Indian Insurance was
Okay. Nasli Wadia. But
That
the Supreme Court judge.
uh,
Nasli Wadia is a Supreme Court.
that is referred to 2009 electricity.
No, the original date.
Original judgment of Nasli Wadia.
The SCC 279.
What is this?
2008.
2008 3 SCC 279.
Yes. This is the paragraph, I think 21, it says, the government resolution dated such and such embodies the guidelines for observance by the public sector undertaking. However, a clarification, genuine, not such and such, such and such. The issuance of such guidelines, however, is not being controlled by the statutory provisions. The effect thereof is advisory in character and thereby no legal right. And then several judgments were, as you know, of the author of the judgment, who always gives many judgments in support thereof. This is also by his reason. That is what I'm saying. So, he has referred G.R. Raghupati and others, 2002 volume 100 DLT, Uttam Prakash Bansal, 1992 to CLR, Punjab National Bank versus Messrs. The Lord Krishna Paper People, and others. Many of them. That is what is summarized in one paragraph or two paragraphs. Yes. This is AIR 2008, Supreme Court, page 876. It is done in paragraph 21. I do not know whether it will tell you or not. Intent of the public will serve.
Yes.
This is what the guidelines. That would appear from the guidelines. Paragraph 22 is the answer. And no legal right is helpful.
Pray for some time so that I can
What times this
go
bench?
through.
Yesterday I anticipated it, so that's why.
My lord, I have all my best efforts to get, my lord, but the query was put by my lords. I made all sincere
And
efforts
this
to,
query was there since the day one, I think.
but this judgment of 2003, I could only be,
No, that's true. That's you have to just go by this.
this judgment is there, and other, this judgment has been followed in some other judgments, as my lords have pointed out. You just go through that. You may grant me one more chance so that I can
And
come
tell
back.
your junior to be more careful in extending the voice.
My lord. My lords, he was only referring to the UP police regulation, which has been
I am
framed in
not
terms.
talking about this matter.
Mr. Das, yesterday's matter. Yesterday's personal appearance matter, my lord is hinting at.
of
You advise her.
You have to be very careful. First, read the law, satisfy your own conscience, then extend the advice.
Understood?
that I have.
And never learn the law from mouth to mouth. You yourself should read. You yourself should read and satisfy your conscience. Somebody has said, that does not mean that it's law. Yes, have you pondered upon this issue? This have been grappling us since last two occasions.
Yes, my lord.
Have you come up ready with this?
No, my lord. What has happened? My case is tagged with this case for the first time.
Then whose case is the parent case?
My one friend
Sir, have you worked on it? Have you any other judgments? It seems that you have been very complacent as the bench has taken up the task.
No, on terms of reference, we are ready on that.
So what are you talking about, sir? You should
My
take
lord, my lord, actually,
you are an officer of the court.
My-
You are
my-
supposed to assist the court to take a correct decision. That is what is expected from the member. He
My
has come up with one judgment very fairly. I must give him a compliment that whatever the judgment he has come across, whether in the favor of the client or the against, he has placed before the court.
my humble submission is, my lord,
But he
that-
should come.
that PMR, that Orissa Police Manual rules, that has been derived taking power of Section 12 of the Police Act. That has been a compilation. That is not as an enactment or legislative act is not there. That has been made
So
by
have you
compiled by
got any authorities on that proposition?
Inspector General of
Have you
Police.
got any authorities on those proposition?
Well, as per the act, my lord, act
Sorry?
says
I am asking you, have you got any authorities? I mean, the judgment of the Supreme Court or such and such authorities means that.
Actually, there is no statutory force. That is why some states
Could you show us that why it has
have already modified
what
the
are the
police act.
principles of the law which has to be applied in order to come to a finding that it has no statutory force? All these principles of law you have to show that these are the principles, guiding principles.
It is simply a compilation. It is made by the Inspector General of Police matter.
May I bring this case, my lord? If you'll also not to fix it to next week so that I will be prepared on this session and address my last matter.
My lord, because of the lacuna, some
We
states
never argued that line. Only because court has posed on the last two occasions.
no, beforehand
You are-
it was this
you are-
question was
now you are raising on.
this question was not raised only.
You should have come prepared. That's what my lord is saying.
This point was already there.
Yes.
Now we have only elaborated that point.
Yes.
Not that the point was not under consideration. This point, precisely this is the point under consideration since last 2 years hearing. Whether it has a statutory effect or not.
Yes.
If it doesn't have the statutory effect, then we need not interpret. That was the
My-
overall view we had
I
taken.
understand from
And now we have elaborated, he came with this judgment and all.
And as we have found that this 2003 judgment is relied on in two subsequent judgments in 2005 and another one is also.
This holds field even today.
So thereafter there is no material you have searched for and further also you may go for. And Mr. Kuntia and
Yes,
Mr. Mishra, I think would be the best person no, you have.
Let me tell you, speak about cheaper.
No, police.
Because in our case,
Against the police department.
But sir, this point was raised on at least on two previous occasions. It was raised, and then we were thinking he was taking a time to ponder upon the things, to go through it.
My lord, if my memory stand, my lord, that this point was raised initially in 20 years back in tribunal.
No,
That was it. I
what we
will examine,
expected,
my lord. I have not examined.
what
Fairly
we
speaking,
expected
I have not
that,
done any homework.
the threadbare examination of this particular point from the member of the bar,
yes.
and to just assist the court.
Nothing said until the 13 I said something. So I cannot have not read the because it has our cases are dismissed by division bench. Again, they approach the apex court. Since the reference is there, it was.
So that is, we are not going to enter into the merits.
That's true.
of the case.
Yes. And another point
because it has to be decided by the bench where the matter would be there on merit. We are here to answer a reference only.
True, madam.
When the questions have been posed, we have to simply give an answer that what is the correct proposition of law, and then we'll revert the matter to the to decide on merit. We are in pursuit of that. We are not going into the merit. Everybody is also saying my case is this. We are not entering into
That's
this.
true,
we are on a proposition of law. Is a special bench to answer a reference on.
In addition to that, I can add one matter. It is a case of unity. Such a provision can be in absence of authority, in absence of legislative competency.
We are not
Mr.
We are not deciding.
Mr. The difference is with regard to rule, if you can note it down, rule 824, that is chapter 25 of the police manual, under which it is written that rules marked with an asterisk have been sanctioned under section 7 of Act 5 of 1861 Police Act. So we are on the issue 824 is the enumeration of all punishments. 834 with regard to black marks. 834 does not carry any asterisk marks, right? Then 836 is effect of 9 black marks. That is asterisk. And one of the punishments in clause F of 824 speaks about black mark or marks. So we are to harmonize this. The reference is whether it will remain permanent till 9 is
HS 9
counted
now.
and he is terminated. If one punishment is granted after 3, then that is out of the
Diminishes or not?
consideration for inclusion in 9, or that will again be considered. These are our this is the reference.
Got a lot.
But during the hearing, it come to our mind by seeing this editorial mark that this asterisk marks are only having
Statutory.
in statutory force, you may say. But as per this Honorable Supreme Court decision, now we are saying the entire police act is or entire police manual is not backed by any statutory force. After, however, we are on the issue whether this asterisk mark, if it is
Have any
having
force?
statutory force, then 834 does not have.
In my book, my lord, in my book, that is the asterisk mark in the 830.
Should we delve into this aspect at this juncture to answer the reference or discharge it? This is what broadly we, I think, question.
There is another ancillary or incidental point that really cropped up from there. If the police manual itself is considered to be an advisory in nature or the executive instruction without has any backing of law, whether in exercise of the FIA, legislative FIA, or statutory the recognitions, any amendment can be brought into that particular document, which per se, whose existence per se was not this statutory in nature.
My lord, some states have already, they have made their new manuals, right? That is why, because this has no statutory force, so that's why after the recommendation
as read by my brother, this particular chapter or something that says that it has been amended or brought or whatever in exercise of the statutory powers emanating from the Police Act. So one can say that these chapters were brought because of the exercise of the powers which is conferred in the parent statute. But where it is brought in a particular document which does not have its statutory force. Whether you can segregate it and say that this is a standalone provision. This is what is the another ancillary point that has cropped up. So, provided we say that it is only executive in nature.
That's subject to Lordship's appreciation. But prima facie, I don't think that is any force.
It is derived from the police act as because it is under rule 824. Rules with the asterisk mark have been sanctioned under
You
section
did
7.
not understand what plays in my mind. What I said was, what you are saying, deriving the inspiration therefrom, I am.
As because punishments have been sanctioned under section 7 of the Act, Police Act. That's why I said that has been derived. And the rule framing power is given under section 12. That is why IG has framed this complaint.
I think that is not a question which you are understanding.
There's no force of law.
That is
Section has no force.
Even for the purpose of giving sanction, you need to have the source of power. Where from you got the source of power? If the manual itself is not a
throughout India, all the states have made this police manual taking that the tax power. And after that, Solicitor of the Model Police Act, they have changed. Most of the states of India, they have changed police manual. Even they have modified the Police Act also. It is near about 15 states have made that. Odisha, West Maharashtra,
Answer.
reference.
Many states have done.
And in view of this 2003 judgment which you have
Yes.
placed it,
Elaborate it
perhaps-
further. Elaborate.
I would have, you have a discussion with
With the
Andrezi
department
along
also,
with
I'll have
this,
to.
What
judgment.
department?
It's legally,
It is not supposed to give you an instruction on law.
that's right. On law, they cannot,
department
but
will
I'll have
give
to
instruction
ponder
on
upon the
fact.
things. Well,
Law is your baby, your baby. You have to nurture it. You have to bring him up.
the consequences has to be faced by the department.
Whatever we, sir, we are not concerned with the consequences. What is that? The maximum said lex, dura lex.
Duralex. Law is hard, but it has to be.
accepted as ours.
Yes.
It does not depend what the department will.
And we don't have the power to say prospective over it.
What do you want? You want further? You want to assist further
My lord,
by
further I'll.
and he will also do that. It seems.
I tell you,
Mr.
if you argue, there, welcome, no difficulty because you have understood the interaction which has been there. If somebody else wants to argue, I think you should communicate with clarity, precision,
Yes, everything.
without any ambiguity to be created, so that continuity can be ensured.
And while
Otherwise,
arguing,
again, de novo it will start.
while arguing some ancillary issue comes, that also you should be capable of answering that. Ancillary issues definitely will crop up.
As one of it just now, I just said. Is an offspring from the main issue.
The former advocate general is there. We can request him to assist also. If there is a legal issue, you can also assist us because you are the former advocate general. You have been relying upon this manual many a time and defending your state, which has no statutory effect.
I can assist with.
He is doing it. You independently, you can also
Right.
assist. You
You're also fixing it.
enlighten us.
You're also fixing next week, next Friday.
Object to Mr. Das convenience.
You have seen Mr. Das impediment.
We want your independent input in this subject,
Right, I understand.
irrespective of what both the sides says.
Now, by now, Mr. Das has examined thoroughly in this issue, but he is undecided how to
No,
communicate.
if I quote Marathi Chief Justice, he is fairly placed in.
No, that's no doubt about it.
He has done it.
What is apparent, I am the person who must say,
Right,
and that is what is the expectation from the
Bar.
responsible officer of the court. That's the part.
Well, I'll send, I'll just come to you, sir. There's a fixing.
This.
Any date, my lord, after 2 weeks, so that.
We are the regular bench, no problem. Convenience of my
I'm always
more.
more.
But here also is the roster master.
Settle.
Wherever we are asked to see, we will see. That is partly heard during the hearing.
Kindly fix it. Kindly fix it.
Subject to the
Convenience of
Most of the ask first.
You please tell us the date.
You just converse amongst yourselves and just
Tell us the date, we will
Alright.
fix it up. No problem.
That will be
All right.
Any date you.
Yes, yes.
Mr. Mishra is also.
all of you agree.
Yes.
So it is the legal submissions to be made.
Try to ensure Friday.
21st,
Whatever.
If
21st, 21st of November.
We expect that all the
Friday.
parties concerned.
Mm. 21st is Friday.
Thereafter, next week, after that, 24th week.
My lord, on 28th, my lord is assisting on Friday, 28th.
Yes, Mr.
As per the order of this honorable court dated 24th October minutes. It's a matter relating to a tender which was revoked twice. Once for administrative reasons, once for technical reasons. And on the
File your affidavits. File your affidavits. 2 week, 1 week. Yes.
item number 2. Milords, interim order to continue, Milords.
Always there.
Item 2.
Item number 2, Manoj. It mattered yesterday. And we challenge the writing of the subordinate legislation of the rule, Manoj. That is contrary to the act. And provisions of the act. Short time to take.
My instruction is today no DPC. In for several months, no DPC is happening. So there is no DPC really is happening. No promotion. There's no movement even in that regard. We'll file a proper counter.
Let that.
Counter, let this. It is submitted by Ms. Roth, the comma.
To move your lordships in case there is any imminent threat of.
She has recorded and she will not
That's
proceed.
good enough.
What more?
Good enough. Great.
One request, there is OP number 3, which is the energy department. I was given to understand that what has happened, this situation has prevailed not only in OHPC but other PSUs as well. And there is some directions from that department itself because of which is happening. I think if that counter would also help and
We have
clarify.
given opposite party, respective
Number-
opposite parties, we have already
Yes.
said so. Cancellation. Who is the petitioner?
Item 7.
Yes, Lordship.
Yeah.
Party cancellation.
Yes.
No, Lordship. To help for the place of business, non-functioning of the place of business. We have verified and field visit report has been submitted by the office authority. Now he is conducting the business.
So he is there.
You destroyed
So
the same order.
Like in that order, that non-filing of returns, that order. Lordship,
no, it is because
You have
of
corrected.
No,
you just corrected. Yeah.
Correct. Some reason.
Yes, call the names.
Item 8.
My lord, here this the appellant has filed the order of the honorable single judge, my lord. The impugned order is at my lord, as page 36, my lord. The impugned order is there. My lord, the impugned order doesn't give any specific direction, neither for the present petitioner nor for the opposite party also. Because two cases, two writ petitions were heard together and the order has been, common order has been passed. Your lordship can see the order in spite of the order by the State Commission on PWD. They have not acted upon it.
He has said that there are certain difficulties which he is permits to ventilate before the authority,
Yes, my
and he will consider it.
My
But
lord,
where is the difficulty?
My lord, they have not given it because the copy is mandatory to be served on the
So
petition.
go there and apprise the court that this
No,
is
no,
not
no,
the error. which
My
is
lord,
the-
the state has been directed, not the myself. The appellant has not been.
So what are you, this
My lord, your lordship can see.
opposite party number 3?
Yes, my lord. The state. They have not accepted it. If there is any impediment, then they should place it before the state commission. A copy should be given to us also. That is the mandatory provision.
Is this coming under the purview of writ appeal?
My lord, because the order passed by the single judge is not a specific order. No specific order has been passed, my lord. As per the, your lordship can see the provision of 81, the rights of persons with the disability, section 81, my lord. Provides that where
Paragraph 6 is very clear. It says that it is not an order, it is a mere recommendation.
Yes, madam.
And then he says that if the district education officer is unable to accept that recommendation, then it is open to him to apprise the commission.
Yes, madam.
That it is not.
Yes, madam.
So,
Madam.
and then he says that I'm giving a liberty to this opposite party number 3 to raise.
Yes, madam. But
and
it has
go
been,
before the commission.
But he has not gone there. And also,
he's gone there. Opposite party number 2 is who? Commission.
Yes, my lord.
So
he has not gone there, man, because in the provision provided that where an authority doesn't accept the recommendation, itself, my lord, your lordship can see.
Sure. That is
My
what
lord,
it says. That the proviso.
Section 81, man.
It is not an order. It is mere recommendation. So it may be accepted. It may not be accepted. If he feels any difficulty in accepting it, then the liberty was given to him to approach the commission and show him that what are the difficulties he faces.
But who has come here?
He has come. He has not accepted. His contention was that is an order. He has said it's the nature of a recommendation. He has also accepted it. And the recommendation does not mean that it is to be followed.
The reproduction was filed at the behest of the education.
This is what it says. He never applies it.
Mr. Das, it was your petition. Writ petition was at your behest.
One filed by us and other by them. Hello.
Oh,
There are two writ petitions. If your lordship will
Acha.
find at page 36, challenging the order of commission.
Has he filed two appeals?
No, what?
My lord,
His one appeal is competent. Tell me, sir.
my lord,
Two independent writ petitions touching upon the same issues have been decided by a common judgment.
my lord.
In both the matters, you are a party.
Yes, my lord.
Can you maintain one appeal?
My lord, I am the petition.
I'm asking. You are a party in both the proceedings. I'm
Yes.
asking you, can you maintain one appeal?
My lord, I am not. I am the opposite party in that appeal, in that petition, writ petition. In one petition, I am the petitioner. In the other writ petition, I am the opposite party.
Please consider what I am saying.
My lord.
Whether one appeal is competent. You are aggrieved by an ultimate direction.
Yes, my lord.
Please consider this aspect. Why not? Why not? Some kind of a estoppel or a res judicata will apply. Ponder upon it.
My lord, the order of this.
If you continue, then let us dictate the judgments. The law will deter. It will stand as a deterrent. Considering the plight of a litigant, I am just pointing it out to you.
Already four of
It is up to you, sir. You have to take a conscious decision. We will not say. We just put query to you. We'll record whatever you will submit. Please look at two Privy Council judgment is against you. That's why I'm asking. I'm beseeching unless the litigant, otherwise the litigant will suffer. Ponder upon. Again, I am rephrasing. There are two independent proceedings touching upon the same issue. In both the proceedings, you are a party. By a common judgment, the court has disposed of both the writ petitions, deciding the common issue. You have preferred only one appeal. Is it competent? I am asking. That's all. Now you ponder upon.
Well, I may be directed to file.
That is up to you. Yes, my brother has to go.
My lord, your lordship, you can pass the order as your lordship desires.
Right of object is a statutory right. All the list.
Item number 1. Well, here is an application for appointment of a sole arbitrator.
Give. Yes.
Yes, this is an application for appointment of a sole arbitrator.
Where is the arbitration clause?
Page number 20. Page 20. Disputes. My lord has it.
And where is the section 21 notice?
Section 21 notice is annexed at Annex 2, page number 21 to 23. Let me come to page number 22, last paragraph. Therefore, we under our client's instructions are constrained to issue this notice under section 21 of the arbitration and conciliation.
Let me find out the dispute.
Page number 20.
No dispute.
The dispute occurred between the parties, my lords, when the petitioner is the dealer for the opposite party, number 1, and he had been appointed as a dealer for its products and services in 2 districts in Odisha. My lords, when the opposite party stopped honoring the agreement and supplying the purchase orders, my lords, then the disputes occurred.
Where is the clause that they will give you?
Dispute clause.
No, that they are supposed to issue you orders.
My lords.
Sales. Yes. Who is for the other side? First time.
First time. It has
Notice.
come for first. Yeah.
3 weeks.
Survey copy and
Service 3 weeks. Next.
My lord, it is an application for appointment of sole arbitrator. The arbitration agreement is on page 27. 27, my lord.
First time.
Yes, my lord.
Show me the arbitration clause.
Arbitration clause is page 27, clause number 19. Any dispute, difference, or claim arising out.
Anything. These are the prerequisite conditions. Have you complied? 5 days.
Yes, my lord. We are basically approached the opposite party for supply of medical equipment. The purchase order page 51.
In an arbitration clause, there is a prerequisite conditions for invoking the arbitration clause. Is 19.1.
Yes, my lord.
Show us that you have attempted.
My lord, the first notice was sent on 1st 12/2023, page 56. First legal notice. Then we have given subsequent notices, and section 21 notice was given on 4th May 2025, page 76 to 80.
Then section 21 notice.
Page 76 to 80, my lord. 4th May 2025. Para number 9 and 10.
Anyhow, service of notice. 3 weeks.
Item 4.
May it please your lordship. Lordship, it's a application for appointment of arbitrator.
True. Where is the arbitration clause?
Lordship, there was a letter of acceptance, unconditional letter of acceptance given to the petitioner. However, no agreement was executed, your lordship.
Show me from the correspondences.
Yes, your lordship.
The parties have for arbitration clause.
Your lordship, if you see annexure 2, it's a unconditional page number 93, 94, your lordship. It specifically says that.
Just wait.
Yes.
Where is the arbitration clause?
Lordship, the contract, the standard form of contract has arbitration clause.
But you know section 7 of the Arbitration and Conciliation Act. You'll have to show there is an arbitration agreement. Otherwise, every dispute is not amenable.
Yes, your lordship.
So, clause.
Lordship,
Any letter, correspondence, from where we can understand the parties have agreed to resolve their dispute by arbitration. So,
Lordship, it's a notice inviting tender. The model contract.
No, first, madam, no. No.
Lordship.
You have to show.
Lordship, the letter of acceptance is unconditional in nature. It basically
that the
concludes
tender
the
document contains an arbitration clause.
Yes, your lordship. The
Where
tender
is that?
document does page number 83, 84, your lordship. It has an arbitration clause.
Just show me.
Page number 83, your lordship. Page number 83, clause 8, settlement of disputes. Initially, one notice has to be sent for 30 days for amicable settlement. That was done by the petitioner, your lordship, and post that only the copy notice of invocation
Section
of arbitration.
21 notice.
Yes, your lordship. It has been given.
Where is that?
It's in. It was issued on 29 December 2024, your lordship. I'm just sharing the annexure.
Show me the letter, madam.
Yes, sir.
Which page?
Your lordship, page number 131 to 133.
131.
To 133. Notice of invocation of arbitration clause.
Notice, 3 weeks.
Obliged.
Item 5.
May please your lordship. The parties entered into an agreement, my lords. I have concluded the agreement, my lords, under annexure 1. If your lordship sees page 40, page 15, my lords. It was for structural fabrication erection work. It contains.
Where is the arbitration clause?
Yes, arbitration clause, my lord. May kindly see page number 31 at clause number 19. Things, my lords. The work carried out.
Which one? Page?
Page number 31, clause number 19 of the agreement.
Where is the section 21 notice?
21 notice, my lords, is at annexure, my lords, 4. That page starts from page number 57. Clearly mentioned, my lords, notice invoking arbitration. Dated 24th of March 2025.
What was the date of the agreement?
Uh,
21.
Sent by email also.
25/7/2021.
Agreement dated 25/7/2021.
Notice.
Item 6.
And we permitted to take notice by email also, my lord, because sometimes.
Whatever.
Yes.
Your lordships, there are 3 work orders. There are total 3 work orders, out of which 2 work orders have that arbitration clause. But the third work order, there it has been missed. That has been intimated to the party through legal notice also, and he has accepted that whole of the amount which is pending shall be dealt with according to arbitration.
Where is that?
I'm just showing you, sir. Your lordship, page number 17. Arbitration clause of 1 work order.
No. Where is the letter accepting that?
Section 21. Yes, your lordship.
No. Where they have agreed that this.
Yes, sir. Yes, your lordship.
Entire 3 contracts that would cover within the arbitration.
Your lordship, we have sent the letter mentioning that in page number 104.
Page 104.
Yes.
And where is their acceptance?
Acceptance is in page number 108.
So they also invoked.
Yep.
They gave you a 3 name.
Yes.
Did you agree?
No, yes, sir.
So?
Because we here clause is for a sole arbitrator. They are asking for a joint arbitrator.
Notice.
Highly obliged.
Item number 7.
Millards, this is a fresh matter, Millards. Millards, arbitration clause is at page 114.
Have you complied the preconditions?
Yes, Millards. There was a conciliation that was attempted, Millards. It didn't yield any result, pursuant to which the notice under
Where is that?
note in the notice it is mentioned, Millards, at page 121.
What? Where?
Page 125, para F, Millards. There is a description of what all events have transpired, and then it is referred that my client had no other option but to invoke clause such and such of the GCC, later invoking 76.1 of the GCC, thereby calling upon EPIL to conciliate the.
Yes, FNG I have.
Yes. So thereafter, Millards, we have gone ahead and issued the arbitration notice, section 21.
Notice 3 weeks.
Millards, both the matters are identically positioned, Millards.
Which one?
There is a sub item also, Millards.
Item 8.
Grateful.
Your Lordship, the letter of acceptance is at page 19, which refers to, my lord, at page 21 to the IRS terms and conditions. At page 21.
Where is the IRS?
Yes, Your Lordship. The IRS, my lord, Your Lordship has it. The relevant portion is page 29. IRS starts from 89, my lord. If Your Lordship comes to page 129, 2905B, my lord, appointment of arbitrator where applicability of section 12(5) of the Arbitration and Conciliation Act has not been waived off. My lord, we come under 2, which is the next page. The first one is for value
below 50
my lord,
lakhs.
50 lakhs. We come under 2, my lord, which is exceeds 50 lakhs. Now, your lordship, there is also a conciliation at page 125 2901. That is also complied with, my lord.
Yes, sir. Why you are not appointing an arbitrator?
But,
What is the nature of the dispute? What is the nature of the dispute?
Well, the two natures of dispute, my lord. One is an unilateral amendments that they have done to these work orders.
I mean, the unilateral variation of the terms and conditions.
Variation of the terms, my lord, I pardon. And number two is rejections of my material which has been already delivered. There are two issues, my lord. My request for arbitration is at page 83.
Why you are not doing
it
it?
is for first time. Let's take it next date. Any date.
I'm
I didn't have any
always
instruction.
against, I'm always against this convention of first time.
My lord, no my
Straightforward matter.
because any date after 1 week.
If the petitions have been served, then at least it is the duty of the
Already I said seek for instruction. Let's keep it next 1 week after any date.
2 weeks.
Yes.
Item 9. As your lordship pleases, man. Deeply obliged.
Recorded order that Mr. Pal.
Your Lordship, I appear for the petitioner, Your Lordship.
Yes.
It's a partnership dispute, Your Lordship.
Where is the arbitration clause?
Your Lordship, it's at page 40, Your Lordship. It starts at page 35, annexure A1.
Page
40, para 20.
So it's a dispute relating among the partners.
Yes, Your Lordship.
What is the nature of the dispute?
Your Lordship,
Account?
the accounts unilateral functioning by one of the partners without reporting to the other partners, siphoning of funds.
Notice 3 weeks.
Fully, Your Lordship.
Item 10.
Which is application appointment by arbitrator.
It's matter of railway and let them serve a copy.
You have not served.
Yes, sir, my lord.
I didn't receive. Yes.
On you?
No, I didn't receive any copy.
No. Service to be affected on you.
Yes. Our office.
You can represent the party.
Yes. I think the railway is the.
Yes. No, give a copy.
Yes.
Yes. This is an application.
Item 11.
Yeah, please, Your Lordship. Lordship, this is an application for appointment of substitute arbitrator, my lord.
Substituted arbitrator.
Yes, my lord.
What the earlier arbitrator did?
It was appointed by Honorable High Court. Two of the presiding.
What he did? Tell me. I asked. I did not ask you who appointed. I say what he did. Why you want a substituted arbitrator?
It was a three-member arbitration tribunal, my lord. The presiding arbitrator and the nominee arbitrator, the respondent recused, my lord.
Correct.
The procedural order at page 147. The relevant page 150, my lord, para 7.
What he did, tell me.
Lordship, they recused the presiding.
Who recused?
Both presiding arbitrator and nominee arbitrator of the respondent, my lord.
Both recused
Yes,
to
my lord.
proceed with the arbitration.
Yes, my lord.
How do we know?
Para 7, my lord, page 150. May I read, my lord?
Yes. Yes, then what could be to be done?
Lordship, we have already served notice at page 145, my lords, for appointment of their nominee arbitrator, lord.
I do not make any comment. I have seen the reason.
Let's say keep it to some other next day. Then I'll try to get it. We don't have any objection about this.
No, I understand, but the reason. Who was your nominee arbitrator?
Justice Beneath Saran, my lord.
Nominee.
Nominee.
Yes, my lord.
And who was the presiding arbitrator?
There was Justice
Krishna
Murari, my lord.
Both of them recused.
Yes, my lord.
And who is the third arbitrator?
Senior Advocate Dr. Adish Agarwal, my lord. He was our nominee arbitrator.
Initially, Justice Saran is appointed. Thereafter, they have suggested the name of the Adish Agarwal.
No. Justice Murari.
No.
There are two, because you nominated one, they nominated others.
Yes.
Both were taken. Now the presiding arbitrator was chosen by them.
Yes.
So now the presiding arbitrator and the nominee of yours both have recused. What?
May I request my lord, let's be taking 1 week after, because the railway has given some instruction. What I'm remembering, this Justice Saran also appearing some of the cases which was filed before the Honorable Chief Justice here. Some cases been filed by this same party, and you are the presiding judge in this issue. What instruction I
So what is the difficulty?
There is no
role of
difficulty to.
arbitrator is also
So I
adjudication.
suggested that there is no difficulty.
Adjudication.
Yes,
There is the difficulty.
there is no difficulty.
There is no difficulty. There is a difficulty.
That
Difficulty is created by Schedule 4.
Yes. That is a.
That's I do not want to. That's why I do not want to make any comment on that. But the difficulty was there. There was no other difficulty.
It must be a separate judicial order, then only can be. Who is the Justice Murari?
Both.
Both.
Para 7, 150.
I think Adish didn't have any objection.
No.
Leave this. Separate order in this regard. Otherwise, ଏତେ କମ ପଇସାରେ କାମ କେମିତି ଅଛି? ଏତେ କମ ପଇସାରେ କିଏ ଦବ?
Who is for the respondent? You.
I'm for this.
Railway.
I'm for this.
Planner DSGI for the respondent, man.
No.
I'm for the petitioner.
Who is the claimant before the arbitral tribunal?
I'm the claimant, man. Petitioner.
The petitioner is the claimant.
Take instruction. 2 weeks.
Item 12.
Grateful, my lord.
Wait, please. Let's in item 12 minutes, the arbitration clause is at page 209 minutes. Clause 87. All disputes and differences whatsoever which shall at any time arise between the parties hereto touching or concerning the works or the execution or maintenance thereof, or the rights touching or concerning the works of the execution of or maintenance thereof of this contract, or the construction, meaning, operation or effect thereof, or to the rights or liabilities of the
I have
parties
got-
or
what is the date of the agreement?
Milas, this is the NIT that your lordship will find. It was floated.
When?
I'm sorry, Milas?
When it is floated?
Yes, Milas will find it at page 27, where there is a reference to the general clauses of conditions of contract. Page 27, it starts. And the relevant page Milas will find at page 36, the arbitration clause. It says the clause 87 of general conditions of contract shall apply. And insofar as the dates are concerned, Milas, the NIT was issued on 9th of September 2020.
Yes.
And the agreement, this is transportation of coal. NALCO floated a tender for transportation of coal. I got it. Then Milas, I have carried out the
non-payment of the charges.
dues. Yes.
Charges.
Yes.
Say that online. What was last invoice that was raised by you?
Last invoice?
Yes, you must have
yes.
some bill.
Yes.
Invoice means bill.
The work completion certificate was 23/5/23. Last invoice, I'll also find. Work completion certificate was 23/5/83.
And the payment was not made.
Yes, they deducted penalty for supplying with a delay.
I am looking for the purpose of limitation. Yes, service.
Yes.
3 weeks.
This is.
You have instruction. Then instruction. What do you say?
They have served copy just now. I will take instruction, lordship. I'll take up 2 weeks up.
Milas may connect this matter with item 22.
Take instruction. Yes. Next.
Milas may tag this matter with item 22. 22 also the same.
Let us reach 22. Unless,
the same parties. Yes.
Mr. Acharya, I do not tag the matter. I have to see the
as your it's the same.
Then I will do it.
Yes,
next.
13. The arbitration clause, your lordship should find it page number 23, my lords.
23.
That is clause 19.1.
This font size is very difficult to read.
My lords, the fonts are very small.
What is the right hand third column to second column or what? Last column.
The right hand side, my lords. Clause number 19, extreme right, my lords, towards the top portion. Arbitration clause 19.
Yes. Then,
my lords, there are correspondences between the parties, my lords.
Have you complied the prerequisite conditions?
Yes, that the documents are annexure 2 series and 3 series, my lords. There were legal notices exchanged between the parties.
Give me a page number.
My lords. Page number is, my lords, page number 25. This was on 27th of December 2023.
Yes.
Yes. And thereafter, now we have invoked the arbitration clause.
Where is section 21 notice?
21 notice is at the end, my lords. Annexure 5 series starts from page number 61.
Notice.
There is a
connected item to this.
Both the cases.
Same, my
Please.
lords. Connected item, the entity is different.
Yes. Oh, see. Okay.